Bill is now open. All we have business before this court, draw near, give attention, and you shall be heard. God save the United States, the great state of Florida, and the honorable court.
Please be seated. We have 3 cases on the calendar today, and we will take the cases in the order in which they appear. We're going to take a short break after the first case and have coffee available in the Commons. First case is Hunter versus the state of Florida.
May it please the court, my name is Edward Bauer, and I represent the appellant, Jeremy Hunter. If I could reserve 4 minutes for rebuttal, please. If I may, I would like to focus my argument on the issue of non-consent, and specifically whether the state adduced sufficient evidence that would permit a rational trier of fact to find the defendant guilty beyond a reasonable doubt. As the trial judge noted during the proceedings below, this case is unique in that the record is essentially devoid of evidence of non-consent. She noted as much, ironically, when she denied the motion for judgment of acquittal. In this case, we have no confession from the defendant. We have no evidence of vaginal tearing or bruising. We have no eyewitnesses to the sexual activity.
Counsel, as a starting point, was this argument presented to the trial court below?
During their motion for judgment of acquittal, they did specifically argue that there was insufficient evidence not only of physical helplessness, but also of consent. Now, the issue the states raised in their answer brief is, which standard of review should apply. Their argument is, well, the special standard of review that's reserved for circumstantial evidence cases should not apply because counsel didn't assert a specific hypothesis of innocence. It did not use the magic words circumstantial evidence or reasonable hypothesis, and therefore the default standard of review, which is whether a rational trier of fact could find guilt, that should apply. I think we should prevail under either standard, and I would like to confine my argument, if I could, to the default standard because I don't think they can meet that. So again, we have no evidence of force, we have no confession, we have no witnesses, and finally, and certainly most important, the alleged victim conceded during her cross-examination that she could not say that the sex was non-consensual. And we know
Isn't that really inherent in the nature of this crime? The crime is sexual battery on a victim physically helpless to resist. If you had, and I remember we had some cases a few years back in the fraternity house here, sexual battery on an unconscious woman who had been drinking too much. Well, surely there would be no evidence of lack of consent.
But in
the person's unconscious.
Not familiar with the facts of that case, but perhaps if you had a situation where the undisputed evidence demonstrated that there was a continuous and uninterrupted period of unconsciousness, or that the person was asleep, where there was no opportunity to consent, I would go along with that. And certainly you wouldn't have consent, and that would meet the burden. However, in this case, she was not continuously unconscious. Her memory from her own testimony, they got to the club at Floyd's between 8 and 8:30. She saw some friends shortly thereafter, and that's the last thing she remembers. She does not remember anything until 1:45 a.m. when she woke up in bed. Now, that doesn't mean she was asleep the whole time. We know she was at Floyd's. We know she walked out of Floyd's. We know she walked to her boyfriend's truck. We know at her residence, shortly before the appellant took her into the bedroom and shut the door, that she told her son...
Well, isn't there circumstantial evidence of a lack of consent? I mean, didn't she rebuff his advances, and wasn't it...
No, I would not agree with that, Judge. When she went on a motorcycle ride with him that evening, he suggested that they date more, and her answer was not no. Her answer was, well, I don't think Christine would like that. Christine was the appellant's ex-girlfriend. So that's not, I wouldn't say she directly rebuffed it. She just said Christine wouldn't like it, which was probably, in fact, true. But she did not say no. I think what's most telling here is late at night, her boyfriend leaves, they're alone, and the alleged victim tells her son, don't let anyone in the house. Now, we don't know what time that was, because the state really never asked any witness what time anything happened, but we know they got to the club between 8 and 8:30. We know they stayed 90 minutes, so maybe they got home 10:30, and the next thing we know is that Officer Rowan arrived at 1:44 a.m. The sternum rubs were used, and they were able to wake her up at that point. But we have to assume it's pretty late. Who else would be coming back other than her boyfriend that late at night? So for her to tell her son, who's 15, don't let anyone in the house, could only be referring to her boyfriend. right before they go into the bedroom and the sexual intercourse occurs, we would say that's pretty significant, and if anything, suggests that it's more likely that the sex was consensual.
How'd she get in the bedroom?
He did carry her in there, Judge.
And she couldn't ambulate on her own.
Well, we don't know. I mean, she was able to walk to the truck when they left the club. However, once they got, and we don't know how far it was from the club to where they lived. They were both within the city limits of Tallahassee. She was carried into the house, but then thereafter she was awake for a period of time. And and again, as I noted, told her son, "Don't let anyone in the house." So she was conscious then. And then she was, just moments after she was speaking, she was carried into the room. But again, we don't know how long they were in the room. That's the problem with this case. It could have been 2 hours for all we know, because the record is essentially silent. We know what time they got to the club. We know they were there 90 minutes, so that takes us to 10 p.m. But from that point on, all we know is...
They didn't go shopping somewhere along the way?
That was before they went to the club, Judge. That was, I think, after they ate dinner, before they went to the club. The boyfriend of the alleged victim wanted to buy a new shirt at Walmart. They went there, and that's when the alleged victim went on a motorcycle ride while they were waiting for him to shop.
Could you give a sequence of when the boyfriend left the victim with the defendant?
We don't know what time he left. That's what's frustrating about this. We know that the first person to leave was the appellant's ex-fiancée, Christine Powell. She left the house first. Then the boyfriend left to go get a pizza. We do not know what time that was. He was gone for some unknown period of time, came back, banged on the door by his own testimony for 20 to 30 minutes before the son, the 15-year-old, opened the door and let him in. So it could have been 45 minutes, an hour and a half. We don't know how long they were in the bedroom. And I think that's the problem with the state's case. I think if they could have established a very tight time frame, that they went into the bedroom at 1 a.m. and the police found her completely incapacitated, couldn't wake her up at 1:30, that would be different. But the state, and it's their burden, they didn't even try to establish a time frame. Most of the times...
I'm saying that the boyfriend might have conducted the intercourse that occurred, because the defendant's semen was found in the...
Oh, we're not suggesting...
victim. So I seem to have a little problem there about how important it would be for the the boyfriend to be on the scene.
I don't think it's important that he was there. I think what's significant is, after he left, that is when, and I don't imagine from the record who in the world would be coming back to her house that late at night. My point is, after he leaves, she tells her son, "Don't let anyone back in the house," and from the record, the only person to whom she could have been referring was her boyfriend, and then she goes with the appellant into the bedroom. We think that's significant, and if anything, is more suggestive that this was a consensual situation as opposed to non-consensual. Now, the state's only argument in their brief on this point of whether a rational trier of fact could find non-consent is just 2 pages, pages 34 and 35, and the only argument they make is that, well, the testimony of the son establishes non-consent. And they point to pages 213 and 214, and what the son said is what I just told the court, which is, well, I was playing video games, Mr. Hunter brought me to my mom told me she was on the couch in the living room, don't let anyone in the house, and then he took her in the bedroom. And then the prosecutor, during the direct examination, segues immediately into a very weird line of questioning where she asked the son, "Can you have a liter of cola?" And where she got that, I have no idea. Kid says no. Well, how would you get it? Well, I would wait till my mom's asleep. Well, why would you do that? Because she would say yes. So what the state's suggesting in their brief is, just as the child could apparently overcome her mother's will while she's asleep, that the defendant somehow got her to parrot what he wanted her to say to her child, "Don't let anyone in the house," and that from that we can infer some sort of evil intent on the defendant's part, and that this was ultimately not consensual. But of course, as I noted...
Well, let me ask you this. It seemed like the EMTs came and they had to use some kind of sternum twist or something.
They used what they
great
called...
difficulty arousing this lady, which seems to, you could draw an inference from that she was totally out of it. That if she had sex, she didn't know what she was doing.
Well, at that time, Judge, at 1:44 a.m., but we don't know what time the sexual activity occurred. All we know is that the club, around 8 or 8:30, they were there for 90 minutes, and that at some point between then, which I guess is 10 p.m. to 1 a.m., the sexual activity occurred So just because she was physically helpless at that point does not necessarily mean she was physically helpless 30 minutes before, 45 minutes before, an hour before.
But if you combine her unconsciousness when the EMTs arrived with the fact that her son testified that when she was carried into the bedroom, her eyes were closed, don't those two facts put bookends around the time?
Well, I think he also testified that her eyes were basically or partially closed when she told him not to let anyone in the house. And, you know, I don't think the fact her eyes were closed means she was asleep. And even so, we don't know how long they were in the room. We have no idea. Could have been an hour and a half, 2 hours. Even assuming she was asleep when they went into the room, that does not mean she was asleep when the sexual activity occurred. And again, this is a case of voluntary consumption of alcohol, not involuntary. So the state was not relieved of its burden to prove non-consent. And I cited the Coley decision from the 3rd District. If there was any evidence that the defendant had encouraged her to drink, facilitated her to drink, gave her drinks, bought her drinks, that, under the sexual battery statute, that would be involuntary intoxication, and that is evidence of non-consent. But the alleged victim consumed this alcohol, and she admitted as such during her testimony on page 115 and 116, admitted that it was totally voluntary. So the state had to meet its burden, and certainly this looks suspicious. It doesn't look great, but nevertheless, the fact she cannot recall what happened is not the defendant's fault. It was due to...
What was the state's theory? What was the condition that made her physically helpless to resist, according to the state at trial? What was the condition?
What they did is they pointed to various parts in time. They said, well, she was asleep when she came home, and that would fall within the definition because it's defined as being asleep, unconscious, or otherwise unable to communicate an unwillingness to act. So they pointed to that. So they look at point A when she's brought home. They look at point C when the paramedics arrive, and then they basically ask the jury to make a finding of guilt based on that, but not when the sexual activity occurred, and they can't even prove when that was.
Well, if he had sexual intercourse with her at a time when she was asleep and she was so out of it she didn't wake up by it, you would concede that consent wouldn't be an issue for that, would it?
Unless you had a strange set of circumstances where someone expressly consented to the sexual intercourse and noted that even if I passed out, don't stop.
If I passed out, it's okay.
Barring that strange event.
What about intoxication? If she was just extremely intoxicated to the point where she really didn't know what she was doing, and he took advantage of that. See, that was the condition that made her physically helpless.
Here's what's interesting, Judge. Her testimony from her. I'll give the court the exact citation, page 111 and 112. She testified that when the police woke her up, she specifically testified that she did not feel intoxicated. She felt fine and was wide awake. Those are exactly her words. Yes, they had a hard time waking her up, but that was eating in my time. That's probably more due to her narcolepsy than the alcohol. It's consistent with how she described her narcoleptic condition, that once she goes to sleep, she's hard to wake up. But her testimony was, I felt fine. I did not feel intoxicated when the police woke me up with the sternum rubs. And I also point out that she was taken to the hospital for a rape kit that evening. They could have taken blood. They might have, but the state didn't introduce any toxicology, reports or evidence indicating that her blood alcohol was so high that she couldn't have given consent. So, again, it's their burden, and they did not meet it. I'll reserve my time. Thank you.
May it please the Court, Josh Heller on behalf of the State of Florida. Judge Van Ork, I just want to clarify your preservation concern. The State isn't asserting that they didn't, they failed to preserve non-consent. That was actually in the judgment of acquittal motion. The State was referring to the fact of the reasonable hypothesis of innocence, multiple hypotheses of innocence that are presumably reasonable, which were concocted by appellate counsel on appeal, are not preserved. So that was what the preservation issue was related to. Since counsel has limited their argument to the issue of non-consent, the State will do the same. Let me start off with what I think is a critical issue here, which is that consent is intelligent, knowing, and voluntary consent. Now, we have a defendant in this, I apologize. We have a victim in this case who testified that she has narcolepsy, and sleep apnea, that she's unable to awake within 1 or 2 hours of falling asleep, that we have facts in this case where the defendant is carried into, the victim is carried into the home, clearly intoxicated. There's an argument in the reply brief that there was some ambiguity as to which time J.W. saw the victim asleep, and the state would assert that the facts are viewed in the light most favorable to the state on a motion for judgment of acquittal. So if there is any ambiguity, the state would assert that when J.W. said that he saw her asleep, which he did actually state in his testimony and with her eyes closed, that that is the time that he carried her into the bedroom. Accordingly, so we have the front end of the being unconscious. We have the back end because she was awoken by sternum rupts, and we actually have the middle in light of the fact that she has sleep apnea. And
is there a possibility that she had sexual intercourse with him at a time when she was not unconscious, very drunk, but consented?
Well, if that possibility exists,
how do we know that it didn't? How do we know it didn't happen that way?
Well, respectfully, Your Honor, on a motion for judgment of acquittal, the question is whether or not the state, even if we do consider it from a circumstantial evidence point of view, whether the state presented evidence that would be inconsistent with that.
Well, I guess that's the same thing I'm saying, is the jury would have to speculate, would it not, that this sexual intercourse occurred during a period of narcolepsy or during a period of, because she does not rule out the possibility that she may have consented.
I think that what that particular statement too goes to in the record, I don't think we're talking about a victim who happens to be a legal scholar and is saying consent from the perspective of knowing involuntary consent as set out in the statutes. I think we're talking about a victim who can't say, maybe I didn't utter those words. But the victim also testified that she often says things that she doesn't remember when explaining her condition. So that doesn't, from that, the jury could conclude that there is not knowing involuntary consent, particularly when you consider the events, even those from some of the defendant's witnesses, that talk about how the victim, when she returned home, removed her pants in front of her child and house guests. Clearly, we're not talking about somebody who is making a knowing involuntary decision as to whether or not to consent to sexual intercourse. And certainly, a jury could conclude that in light of the facts of this case. Now, I wanted to...
Are you arguing here that she was, in fact, acting so promiscuously that she couldn't possibly have known what she was doing?
No, Your Honor, that's certainly not what I'm arguing. What I'm arguing is that from the facts and circumstances...
I'm just trying to look at it from his point of view. It seems to me that, and I'm sure he regrets his behavior.
One would hope so, Your Honor.
Particularly now. But, it just seems like if you were in that situation, if he himself had a few drinks, maybe he made a bad decision, but maybe he thought it was okay.
Well, Your Honor, I think that whether or not that is certainly, the jury, these are a lot of arguments that I think would be appropriate in closing. That, this particular circumstance could be the events that happened. This particular circumstance, and the jury is free to make those conclusions. Certainly a jury could say that and acquit the defendant as a result. But what the state presented was sufficient evidence that the victim did not know, that from which a jury could reasonably conclude that the victim did not knowingly and voluntarily consent in this case. In fact, there is no evidence anywhere in the record that the victim actually consented at all. There's no testimony to that issue at all.
What about the victim's telling her son to not let anyone back in the apartment?
I think that's a good question, Judge Van Nortwick, but I think that it's one that defense counsel, or that the appellant's counsel makes a little too much hay over. I think there's a number of ways that particular series of facts could be considered, and certainly the one that appellant counsel has presented now could be one of those. However, it could also be seen as the victim knew that she was falling unconscious and wanted to ensure that her child had locked up the house and maybe didn't even realize that her boyfriend wasn't there at that time because she was so intoxicated. Of course, there's also the circumstance that the defendant had, I would suggest that the most reasonable is that the, under the facts of this case, is that the defendant planted that idea into the victim in order to have her resuscitate that.
Is there any evidence of that?
I think that if the court looks at J.W.'s testimony with that regard, I don't think, particularly in light of the fact that there certainly wasn't a relevancy objection, so I think everyone at trial certainly knew exactly what this line of questioning went to. When the question about when the victim was asked about, or when J.W. was asked about the victim's condition at the time, in order to deal with, and again, remember, we're talking about a 14-year-old child that's on the stand. The prosecutor asked about whether or not, or Have you ever had trouble waking your mom up? Yes, ma'am. Are you allowed to drink a liter of cola? No, ma'am. Okay, if you want to drink a liter of cola and your mom was sleeping, what would you do? Ask her. Why? Because she would say yes. Is she like awake when you're asking her? No, ma'am. Okay, does she remember you asking her? No, ma'am. Clearly, that testimony was intended to demonstrate the circumstances in which the particular, the victim's, in which the victim was at that time, that this was akin to prior circumstances that J.W. had experiences with her before, and accordingly that was what it was like at that time. Now, accordingly,
Clearly, that would show that she could be influenced to say something that if she were awake and sober, she might not say.
I think that's
right.
right.
That doesn't mean that the defendant actually planted that information for her to then tell her son.
It doesn't necessarily mean that, Your Honor, but what it does do is it provides sufficient facts for the court to determine as a matter of law that the question should go to the jury. And that's what we're talking about here, is whether or not the jury should decide these issues.
What about this? It almost seems like what you just stated puts the situation in total equipoise. She says something when she's asleep she doesn't mean. Just as rational to say he might have asked her to engage in sexual intercourse, and since she was asleep, she said yes. And how would he know that she was suffering from narcolepsy? Is that in the...
Well, Judge Browning, and if that was perhaps the only fact in this case, then maybe it would just be an equipoise. But that's not the only fact in this case. We have a victim who was carried into her home, which either the defendant did or the defendant saw happening. The defendant was placed in her bed. The defendant took her out of her bed and carried her out to the couch where this particular interaction with her son occurred. The defendant who helped her while she was vomiting as a result of being drunk, that the defendant carried her into the bedroom with her eyes closed while she was asleep, according to J.W.'s testimony, and that the defendant's semen was in the victim's vagina, and that the victim had to be awoken by sternum rubs, which are I remember your question earlier, and what it is it's a knuckle technique where the knuckles are rubbed against the sternum in order to wake someone who is unable to wake. And she had previously been unable to wake as her boyfriend attempted to wake her. She was unable to wake at the initial time that they did sternum rubs, and they had to do a second set of sternum rubs in order to wake the victim.
As you addressed, the opposing counsel mentioned that the timeline in this case, for want of a better word, was somewhat confused. Do you have a better grip on just how the time developed on this?
Your Honor, it was my recollection from the record that the boyfriend had left the house and returned, I believe it was 30 minutes, but I could be incorrect. That was certainly what my recollection was, but I admit that I could be incorrect in that. However, I think the ultimate point that counsel was getting at with regards to the timeline is really a jury argument, that if the timeline is questionable, then you could find that she had consented, that she had awoken, and therefore you can find him not guilty. And that's absolutely an appropriate argument to make to a jury, but what it's not is it's not a basis of judgment of acquittal.
But it's your burden to prove non-consent, right?
That's correct.
What is the evidence of non-consent?
Here, the victim was carried into her home intoxicated. Vomiting, that she had to be carried to the couch. J.W. testified as to her lack of ability to, at the time, what her condition was at the time, that she was carried into the bedroom, that she has sleep apnea, narcolepsy, and that she had to be awoken by sternum rubs. The state would suggest that a reasonable jury could conclude, based on those facts, that if there was any consent, which there is no testimony that there ever was, if there was any consent, that it was not knowing and voluntary in this case, and that a reasonable jury could so conclude. Accordingly, judgment of acquittal was properly denied. One other issue that I wanted to address is the defendant, or the appellant in this case, has talked about involuntary intoxication, that the defendant wasn't the person who intoxicated her. That's not really appropriate for the elements of a crime. What defense counsel appears to be talking about is that involuntary intoxication is not a defense to commission of a crime, it really doesn't have anything to do with whether or not the elements are present for knowing and voluntary consent. Accordingly, the state would respectfully suggest that the trial court properly deny judgment of acquittal in this case because there is sufficient evidence from which a jury could find a lack of knowing and voluntary consent, and the state respectfully requests that you affirm.
I would refer the Court's attention to the Coley decision in the 3rd District from 1993. The state's argument in that case is exactly what they're arguing today. She used cocaine and alcohol. She couldn't have consented. And the Court went meticulously through the history of involuntary intoxication and said, no, state, you are not relieved of proving non-consent. It is still your burden because it was voluntary. And what they held was it's not enough that alcohol or drugs may have confused the victim's judgment or reduced inhibitions. That is not enough. If it had been involuntary, it'd be a different story. But I think I have this correct here. The 3rd District plainly held that in a case of voluntary intoxication, the state is not relieved of its burden. The state would have to prove that she was utterly, totally incapable of consenting. And I would submit that since we know that right before they went into the bedroom, she told her son, don't let anyone in the house. If she's capable of making that statement, which he just suggested required some amount of judgment. Well, maybe she told him that because it was late and wanted to make sure he was safe. If she's engaging in that sort of thought process, she's not utterly incapable of consenting.
Yeah, but Mr. Heller says that that's a good argument for a jury, but there are other facts that would entitle a jury to find non-consent. So what do you say to that?
I would say there are no facts. I mean, there is no evidence of non-consent. The trial judge, which is so strange about this, she noted, and under Tipsy Coach, I know it doesn't matter why the judge did what she did, but she said there is no evidence of non-consent in this case. If this was just sexual battery, I would grant the motion for judgment of acquittal. She actually says that. I didn't bring my notes up here, but that's when she denies the motion, she said it on 2 occasions. There is no evidence of consent. What the state did was essentially blend the evidence of helplessness into consent and make it all the same thing. That, well, if she was helpless when she was carried into the house, if she was helpless when the officers found her, then therefore it was non-consensual. They're 2 distinct, separate elements. The state had
to prove that she did not consent, and they didn't carry the burden.
Absolutely. And I would also note that in Bullington, the 3rd District expressly held that consent does not need be expressed. It can also be implied, and that was a sexual battery case as well. So we would ask the Court to reverse and discharge the defendant or order a new trial with a proper jury instruction. Thank you.
Thank you. We will take a short break.